Good afternoon, everyone. Welcome to our last legal philosophy seminar this year, Legal Philosophy Between State and Transnationalism. We're extremely honored and pleased to have with us today such a distinguished speaker from George Washington University, Paul Schiff Berman. Will be giving a paper today. At George Washington, Professor Berman is the Manat On Professor of Law, and he also serves as the Vice Provost for Online Education and Academic Innovation. Prior to serving as Vice Provost, he was also the Dean and Robert Kramer Research Professor at George Washington Law School. And before that, he was Dean and Foundation Professor of Law at Arizona State University. He's also taught at the University of Connecticut School of Law, as well as at Princeton in the program in Law and Public Affairs. He was educated, did his undergraduate degree at Princeton University, and after that, but not after trying a career as a theater director, professional theater director in New York as well, decided to go to law school and earn his JD from NYU. Earlier in his career, he also clerked for Chief Justice Harry T. Edwards of the United States Court of Appeals for the District of Columbia Circuit. And after that, he also clerked for Justice Ruth Bader Ginsburg of the Supreme Court of the U.S. Professor Berman's areas of research and expertise range quite broadly. These include legal education, international and comparative law, law and globalization, law and public affairs, and law and culture. He's the author of numerous books and scholarly journal articles in all of these areas. And his most recent book, which I brought a copy along, Global Legal Well read. Global Legal Pluralism, Jurisprudence of Law Beyond Borders, was published recently by Cambridge University Press just in 2012. And this book, like much of Professor Berman's work, focuses on the significant issues and challenges that globalization raises for the interaction of legal systems. So a very important topic, and one which is being faced by more and more legal systems and jurisdictions around the world. He's also the co-author of a leading case book, which explores legal issues surrounding online activity as well. So we're extremely pleased to have Professor Berman with us today, and look forward very much to discussing his paper.
Thanks so much.
Welcome.
Thank you. I'm going to stand up because it's 2:30 in the afternoon, and maybe I'll fall asleep while talking if I don't stand up. I did have a little bit of a cookie, so I'll use some sugar to get through it. So thanks for inviting me. I have been an administrator for the last few years, both as a dean and now as vice provost for online education and academic innovation university-wide at George Washington University. So it's always great when I get a chance to get out of my administrative role and get to engage with the ideas that I've been exploring for a number of years as a scholar. So I'm pleased to have the opportunity, and if anyone wants to talk about theater directing or online education, I'm happy to do that also afterwards. I have been working in this area of legal pluralism now for about 15 years. And when I started, there obviously had long been people looking at legal pluralism, primarily two strands of scholars, one within anthropology and a whole group of scholars who had looked primarily at the interaction of legal and quasi-legal systems, often under conditions of colonialism, where a colonial legal system would sit on top of an indigenous one and sometimes purport to stamp it out, but not actually. And what scholars looked at is ways actors strategically used one legal system against another, or gained leverage in one place versus another, or in other ways had interaction. And then there was another group of scholars who looked at church-state relations, in particular, going back centuries, at sort of the uneasy relationships between religious authorities and secular state governmental authorities. And so there were both these strands of legal pluralism out there, but very few people, at least at that point, had tried to look at the international, transnational, global, whatever you want to call it, arena through the lens of legal pluralism. There's now far more people doing it, but at the time, there were very few. And so there was this move of legal pluralism to this idea of global legal pluralism. And I thought that legal pluralism would be a very interesting and useful way of analyzing the international and transnational arena for a couple of reasons. One is that it's a locus for intersystemic interaction. So you have multiple authorities or purported authorities. Some of them clearly have a mantle of traditional formal law, some of them less so. And there's interactivity going on a day-to-day basis. And so people are managing these interactions, and it would be useful to have a theory other than some of the traditional state-based ones to think about what was happening, just as a descriptive matter. Secondly, I thought it would be useful because, at least at that time in the United States, and frankly even now in the United States, international law was and is bogged down with a lot of debates about whether international law is law or isn't law. Is it really a legal regime, or is it just norms or something like that? And there was a lot of time and effort and energy spent on these debates, and I actually thought that they were quite fruitless. Primarily because it seemed to me that law has impact separate from what its formal status is, often. So we often obey or feel ourselves bound by norms that might not be traditionally legal, and yet we feel bound by them, and so they have real impact in the world. Or they may be norms, let's say human rights norms, where if a group of governmental administrators, the Secretary of State and this person and that person are all getting together, and they're figuring out what should our policy be, and they say to themselves, well, what would be the international human rights consequences of this? It doesn't really matter whether that international human rights norm is a norm, a law, an edict, something or another. It's having an impact in that room at that moment because someone mentioned it. And so I thought it was more useful to look at what is it that people come to believe over time is relevant to a policy discussion. Or what is it that populations, communities over time see as relevant? And that's much more interesting and probably much more determinative of what really happens in the world than some formal definition of whether it counts as law or not. So I know some of the people who are in this the class that's connected to this talk read my review essay of work on international law by Jack Goldsmith and Eric Posner. And part of the reason that I think that their way of thinking about international law is not very useful is just what I said, that international law can have an impact, or norms that are asserted by some other country or some other entity can have impact partly because somebody within that government or within that hierarchy can use the arguments to gain leverage in their own system, and partly because populations over time come to think that it's important that their government pay attention to something, whether or not that something is formally law or not law. And so it ends up that these things have real impact. And legal pluralism allows us to look at efficacy on the ground in day-to-day interactions in all the complex places where law and norms are worked out, rather than having abstract discussions about formal status. So for both of those reasons, I thought that legal pluralism might be a useful rubric for looking at the global arena. But then we have an interesting problem, or at least obstacle, which is that legal pluralism was historically a solely descriptive enterprise. And for most anthropologists, it remains a descriptive enterprise because that's sort of what they do. And so you have a lot of pluralist studies that look at a particular social field, whether it's a formal governmental entity or somewhere else, and they catalog the range of interactions that you see among the different legal systems or among the different legal actors. And you end up with some really fascinating case studies, and I'm not criticizing them at all. I think they're great. So from a descriptive point of view, I think that's very useful. And from a descriptive point of view, although at the time when I started in 1998, 1999, it was actually very controversial to say that the global arena was an arena of legal pluralism, now I get much less pushback on that. Even people who criticize my work focus on the normative side, and they sort of accept that the world is plural. The legal world is plural. That I consider a huge victory of the last 15 years of scholarship, frankly. That now most people recognize, even the most die-hard nation-state sovereigntists, recognize that the world is made up of a lot of different entities asserting a lot of different norms with a lot of different ranges of coercive power connected to it. Some formal, some not formal, but even the ones that are not formal having real impact in the real world on real decisions. And as a result, as a descriptive matter, legal pluralism is much less controversial than it once was. Okay, so now the question is, might there be a normative project in the pluralist perspective? That's more controversial. But let me try to play out at least a little bit of what that would look like, and what that would mean in terms of how you would design legal institutions, how you would design procedures within your legal institutions, and how you would think about intersystemic problems. So that's what I'm going to try to tease out. All right, so let's think about how we encounter a stranger, any stranger, somebody who is different from us. And let's say we have a disagreement with that stranger about something. You could say, well, my rules win because you're on my territory, let's say, and you have to play by my rules. That's what I call sovereigntist territorialism. So it's based on sovereignty, it's based often on physical territory, it's often based on nation states, doesn't have to be, but it could be. And the idea here is, if you can locate something in space, you can figure out whose norm should control it. And for a lot of our interactions in the world, that's okay. I'm not criticizing that as a rubric for understanding the world, at least some kinds of interactions. If I walk out of here and some car runs me over, and I want to sue that car driver, it's not crazy to think that the laws of Toronto or Canada should apply to that particular problem because it happened here, although I'm not from Canada. Now, if it's because the car was faulty and the car was manufactured somewhere else, we quickly start getting into more complicated questions of jurisdiction and legal norms and so forth. But at least for some purposes, locating something in space and figuring out who controls it and saying that that entity controls it works some of the time. The problem is it doesn't work all the time, and as soon as problems start getting complex and activity crosses territorial borders, it gets very, very difficult, and you end up with, in a sovereigntist territorialist scheme, a set of inquiries that are, whatever their merits, they're not really about what most people think the issue should be. So I'll give you an example. There's a celebrated case involving whether the internet service provider Yahoo could be sued in France because of Nazi memorabilia and Holocaust denial material that was uploaded from servers in the United States onto Yahoo auction sites and then downloaded by French people. Legal in the United States under the First Amendment, illegal in France because of their hate speech laws. And the question is, can France have jurisdiction over Yahoo to apply its law over Yahoo? Not Yahoo.fr, the French subsidiary of Yahoo, that's easy, but over Yahoo.com. All right, so that's a really hard problem, and I'm not sure there is any good answer to it. But here's what I do know. The answer should not turn on what it actually did turn on, which is the physical location of the stock certificate by which Yahoo.com owned Yahoo.fr, and because it was in a safety deposit box in France, as opposed to Switzerland or the United States or the Grand Caymans or wherever, France can have jurisdiction. That strikes me as not the way a legal system should be organized, because it's not really talking about anything that's real in terms of the relationship that Yahoo had to France. So the problem with sovereigntist territorialism is, frankly, it's not going to work in all circumstances because there are lots of disputes that can't easily be grounded. And in addition, it doesn't really capture all of the potential community affiliations that might be at play. All right, so that's one alternative. Another alternative is to say, look, when you're encountering a stranger, is to say, you're not really a stranger at all. You're just the same as me. We actually have the same norms and the same beliefs. And if we don't, then maybe we'll hash them out and come to something where we both can agree on a single set of harmonized norms. So that's what I call a universalism, a universalist solution. And that could be international human rights norms, it could be religiously based norms, it could be other kinds of uniform rules that are often created in commercial settings and so forth. And again, as with sovereigntist territorialism, I'm not criticizing those. Good to have some universal norms. Sometimes it's an easy way to solve the problem of multiple legal systems is to figure out some set of rules that everyone agrees on, and that's great. However, it is very unlikely, I think, and I might even go farther and to say probably not a good idea, even if it could happen, that we would have one overarching set of rules to govern everything worldwide. Because people are different, communities are different, and my guess is that any time you start to create any sort of uniformity, you'll get people undermining that uniformity on the ground in actual practice. Because a lot of the affiliations we hold most dear as people are not necessarily one single universal community set of norms. So although sometimes sovereigntist territorialism and sometimes universalism might work, we might want to think about some other way of dealing with multiplicity. Another problem with sovereigntist territorialism and universalism as approaches is both of them are what Robert Cover would call jurispathic, which means, what he means by that is they kill off competing legal interpretations. So think about this. You've got a group of possible legal rules, norms that might apply to some sort of dispute. And the question is, how do you deal with that? Well, if you say, we're located here, my rules win, all these other competing ones go away, that's killing off, in a metaphorical sense, those other legal rules. If, in contrast, you say, oh, there's all these legal rules, but let's go to one universal norm that we can all agree on, that also, though it's a little bit less violent, is also killing off the multiplicity and the competing ways of understanding whatever the issue is. And so both approaches are fundamentally jurispathic. Now again, nothing wrong with that sometimes. In fact, anyone making any decision among competing norms ever is going to have to be at least somewhat jurispathic, right? Otherwise you can't make a decision. So it's not that, that there's anything intrinsically wrong with that, but we might sometimes choose instead an approach that would be more jurisgenerative and less jurispathic. Jurisgenerative means generating more avenues, more ports of entry for legal rules, for legal norms to be heard. More ways in which different populations can have voice and can have their perspectives heard. And could you think of, or could you come up with, a set of institutions or a set of procedures that would allow more voice in that way, instead of stamping out voice? All right, well, how would we do that? So we might invoke Hannah Arendt, who talks about a mental capacity appropriate for an active relationship with that which is different. A mental capacity appropriate for an active relationship with that which is different. Not stamping it out, not saying it's not different, but trying to get into an active relationship with that which is different. Here's another example. Iris Young, political philosopher, talks about the ideal that we could envision of an unoppressive city. Lots of people from lots of different ethnic backgrounds, lots of different races, lots of different communities, lots of different food preferences, lots of different language preferences, lots of different clothing preferences, all living in really close quarters. And if you were in the ideal city, you'd be in a city where people don't try to turn the other into them, but also don't lob rocks at the other, but instead live in harmony, share certain things, communicate, oh, how do you do this? Oh, I do it this way. Oh, that's interesting. You know, maybe we could do it yet a third way, etc. And we have dialogue across difference. If you could do that, that has some intrinsic advantages, it seems to me. And is it possible that legal pluralism could help us think through certain mechanisms that would be more likely to be jurisgenerative, more likely to lead to this active engagement with the other, than either sovereigntist territorialism on the one hand or universalism on the other? All right, so what could we look at? Well, we could look at, and what I advocate in my book and in the article that was assigned for today, I guess, is pluralist mechanisms, procedural rules, institutional designs, or discursive practices, just customs, ways of interacting, that will tend to build into the decision maker, whoever the decision maker is, it could be formal law, not formal law, but any decision maker, to build into the decision maker a habit of mind that fosters interaction and adaptation. So I'll say that again. Procedural rules, institutional designs, and discursive practices that will tend to build into the decision maker a habit of mind that fosters interaction and adaptation. Now, that's not a strong normative position. It's not saying which rules should win in which situations and which norms are better and so forth. It's not even saying necessarily in all situations which procedural rules should win. But what it is saying is that when you are making up procedural rules or you're designing institutions or you're thinking of the practices you might want to have, you might want to put on the table these values of pluralism as at least one factor to take into account when you are analyzing whether this set of rules is a good one or not. So let me give you some examples of such mechanisms. But before I do, I just want to give a little bit of a caveat. So one of the sad things, if you're a pluralist, you're interested in both formal law and quasi-law or norms that may not have the formal status of law and so forth. And so it would be great if I had a huge number of examples that were both formal law examples and less formal law examples. The problem, however, as a practical matter, is that less formal law is harder to find. It tends not to get written in court decisions. It tends not to get reported quite so much in newspaper articles. And unless you're going to be an anthropologist going around doing thick description and case studies, it's hard to find examples. So most of my examples tend to be formal governmental courts and governments of the sort that are familiar to us as lawyers, but I think the principles would be true regardless of whether we were dealing with a formal legal mechanism or not. All right, so let me give you some examples, which are, most of them I think are also in the article. European Court of Human Rights has a thing called the margin of appreciation doctrine. Most of you probably know what it is. It's an idea that the court would, instead of simply hierarchically imposing a norm, would articulate a norm, but then provide some wiggle room, provide some opportunity for the individual constitutional courts to move towards that norm over time as individual cultural circumstances dictate. Recognizing that there are differences from culture to culture, even within Europe, and that some of the norms may be harder for some of the constitutional courts to get to. All right, so the margin of appreciation doctrine, we can have debates about whether it's used well in this case or used poorly in that case, but as a principle, what's interesting about it is it has been criticized and was originally criticized by both nation-state sovereigntists on the one hand, who really didn't want the European Court of Human Rights to have any hierarchical power at all, and international law triumphalists on the other hand, who saw the margin of appreciation as a kind of giving in to these recalcitrant nation-state constitutional courts that didn't want to really move in a more robust pro-human rights direction. And so both camps sort of viewed the margin of appreciation doctrine, and I think still do to a large extent, as what might be called half-a-loaf solutions. Half a loaf is better than none. That I want to get, I wanted to get everything, I couldn't get everything, so I only got half. Okay? So we'll live with that. I want to argue that from a pluralist perspective, the margin of appreciation doctrine is actually a loaf and a half solution. It's actually a better solution than if either of the two sides had won, because it creates structural interaction. It means that when you are a judge on the European Court of Human Rights, you have to be thinking about what the local cultural context in all of Europe is of the decision you're about to be making. And it means that when you are on the constitutional court of a particular country, you have to be thinking more about your relationship to the European Court and where you have wiggle room and where you might not have wiggle room and so forth. Another example, also used a lot in Europe, is subsidiarity, which actually comes from the Catholic Church, and it's the idea that you should push decisions down to the most local level. where they can be decided. I'm actually not that interested in whether it's the most local level or not the most local level, but I am interested in subsidiarity because it is an institutional mechanism that forces the decision maker to think about whether there is some other decision maker somewhere else who is better situated to decide question X. And again, I don't care so much whether it's more local or less local, but I do think it's useful to have anyone who's asked to make a decision to at least think, should I be the one making the decision, or is there someone else who's better situated? And maybe the answer is I am the best one. But if you've actually asked the question, you are inculcating, what did I say, a habit of mind that fosters interaction and adaptation. Local example, Canada. Canadian Constitution, the notwithstanding clause in the Canadian Constitution, which allows provincial governments to reenact legislation even though the Canadian Supreme Court has declared it unconstitutional for a period of time, and then it can come up before the Canadian Supreme Court again. Again, my understanding is it hasn't ever quite gotten to that place, but the fact that that clause is there, again, creates structural interactions, creates the requirement that each entity be a little bit more aware of the other entities, and I would argue that just having that provision, even if it never actually gets invoked, pays some useful dividends. Mixed tribunals. So if you've got a tribunal, particularly in an area with a lot of strife among communities, maybe ethnic groups, maybe racial groups, maybe language groups, etc., religious groups, having a tribunal where there are members of multiple groups together deciding may actually be more useful than not having that. Partly it may lead to better decision making. There's actually some good empirical data on the fact that diverse juries actually reach more accurate outcomes than more homogeneous juries. But also it may be that those decisions will be seen as more legitimate because they involve decision makers from multiple perspectives. And so particularly in the context of post-conflict justice, some have argued that hybrid courts are a better solution than either international courts on the one hand, which tend to be seen as removed from the local context and maybe illegitimate, and on the other hand, a purely local tribunal that may not have the resources, that may be subject to capture by one or the other ethnic group, and that may also be seen as illegitimate for that reason. And so to have a mixed tribunal instead might be better. The entire conflict of laws framework, if used well, or what some call private international law framework, that is jurisdiction, judgment recognition, and choice of law, could be used explicitly to not wipe out jurisdictional overlap, to allow play in the joints among multiple decision makers so that there could be more interaction among them. What's an example of that? Well, federalism in the United States and to some degree in lots of other countries, Canada as well. If you've got local entities, states, provinces that have power simultaneous and sovereignty simultaneous to the federal, and they have to work it out, that creates lots of tensions. It creates lots of inefficiencies, arguably. It creates lots of uncertainties, but it creates lots of interaction. It creates the opportunity for what we might call laboratories of democracy, where certain entities can try out alternative schemes without getting forced into a more uniform scheme and so forth. We can see other examples of this even in situations where the assertion of jurisdiction isn't literally successful. So the most famous example of this in recent times is the Spanish judge Juan Garzón asserting jurisdiction over Augusto Pinochet, former Chilean dictator, and he didn't win in the sense that Pinochet was never extradited to Spain and did not stand trial in Spain. But what did happen as a result simply of the assertion of jurisdiction is that we had a 2 or 3 year debate in the world about head of state immunity and whether it should apply to human rights violations. And perhaps even more important, it galvanized actors within Chile itself to pursue human rights prosecutions against not only Pinochet, but others of his regime. And so it became a mechanism for leverage. So when we talk about does international law or transnational law have impact? Well, in one sense, it had no impact. Garzón asserts jurisdiction. Who cares? He never goes. Did it really have impact? You bet it did, because actors within Chile used the possibility of Garzón coming in as a way to gain leverage within their own country and their own political system. Another example of that, Sally Murray and Rachel Stern have written eloquently about women in Hong Kong who wanted to inherit property. And for years were trying to change the inheritance rules unsuccessfully. And then by using the idea of the drafting and implementation of the International Convention to eliminate all forms of discrimination against women, to frame it as a women's human rights issue, were able to gain leverage within the Hong Kong legislature that they were not able to get simply as a local matter. That's another example of law, international norms having an impact. Again, whether Hong Kong officially adopted CEDAW or not really doesn't matter. So let me give one more example in the choice of law and recognition of judgments context. So there was a case, a couple cases in the United States, one involving Bob Jones University, which is a university, religiously based university, and they didn't have intermarriage or interracial dating among different races. But they wanted a tax exemption from the Internal Revenue Service as a not-for-profit, and the IRS refused to give them a tax exemption. And the Supreme Court affirmed that really just as a matter of, it was sort of deference to an administrative interpretation of their own rules. And Robert Cover, famous pluralist in the United States and scholar, objected. He didn't object to the outcome of the Supreme Court decision, but he objected to the way the Supreme Court got there, both because it didn't take seriously enough the religious claim of Bob Jones University, and because it didn't take seriously enough the claim, it also did not require the Supreme Court to put on the table some important norm, namely the 14th Amendment equality norm, as a reason to not allow Bob Jones to have the tax exemption. So consider instead, if we had thought of that as a choice of law case between a religious law and US federal law, then what would have happened is we would have taken seriously the religious claim to say, this is our community's law. We would have tried to defer to it, if we could have deferred to it, unless there's some overwhelming command that says we can't defer to it using what's called the public policy exception. And in this case, there would have been one. There would have been the 14th Amendment equality norm, which is a core constitutional principle. We fought a whole civil war about it, and so on and so forth. And so it would have solved Cover's objections, because it would have both taken seriously the competing claim and required a strong justification for why that competing claim gets stamped out. So if you're going to be jurisπathic, you're going to explain why you're being jurisπathic in this particular case. In contrast, another case decided in a similar time period, we have a case where an Indian tribe is using peyote in a ritual, a drug that is illegal under federal law. So the question is, should federal law trump there? Well, there, the federal command is much less strong than the equality norm of the 14th Amendment. It's simply a federal drug law. And the community, in this case, is operating in a pretty insular way. And it's part of their own religious ritual. And so unlike what the Supreme Court did, a choice of law framework that took seriously the competing claim would have allowed the competing claim to win. So sometimes it could change the outcome, sometimes it might not change the outcome, but it would change the prism through which you analyze it. Last example from recognition of judgments. There's a libel case in England between two people, and as you may know, England's libel laws, at least at the time, were much less protective of publishers than US First Amendment law is. So much easier to win a libel case in the UK than in the US. So someone wins a libel case in the UK, the defendant, instead of paying the money, moves to Maryland. Plaintiff comes to Maryland and says, please enforce my judgment. Maryland court says, we can't enforce the judgment because it would be unconstitutional for us to have issued that judgment in the first place because of our First Amendment, and therefore we can't enforce the judgment. I think that's wrong. I think that's wrong because the decision to enforce someone else's judgment is completely different from the decision of whether you would have reached the same conclusion in the first place. And it may be that there are some judgments that you wouldn't enforce, like maybe a Nazi judgment or a judgment that had no due process whatsoever. But a judgment that was issued by a British court using British norms should not be denied recognition simply because you disagree with it. And again, if you think about this much more through a pluralist lens, it becomes easier to see that sort of thing. So what are the principles that I'm using? Don't wipe out competing possible ways of analyzing the problem. Try to maintain jurisdictional overlap to the extent that you can because it provides more ports of entry, so someone who's not heard in one place can get their voice heard in another place. Consider community affiliation and different communities that might possibly be relevant to a decision. Try to defer if you can, and think of the systemic values that, for instance, come from recognizing another entity's judgment, even if it wasn't the one that you would have come up with in the first place. That has an important systemic value, even if in the individual case it might not be your preferred outcome. When you can't defer, because it's a Nazi judgment, or it's something that's so far beyond the pale, or it conflicts with some core tenet of your community, like the 14th Amendment's equality norm, then at least you can explain why you are being jurispathic in that particular situation. And design your institutions with an eye towards creating opportunities for dialectical interaction. Create a federalist system rather than one that has only one government, because that'll create dialectical interaction. Create a margin of appreciation, because that'll create dialectical interactions, etc. Now, that doesn't solve every conflict in the world. And it may sometimes be the case that even though you've got all of these legal pluralism reasons to pursue a particular procedural mechanism, you might say, well, in this particular case, having a dialectical interaction is just going to create total chaos and it's going to be horrible for some other reason, and therefore I'm not going to do it. That's fine. I'm not saying pluralism always wins. I'm being pluralist about my pluralism, right? So it's just that it should be, I think, a set of values that are on the table when you are designing your procedural mechanisms, when you are designing your institutions. Now, why are we doing this? Because providing those extra moments of voice, providing those extra ports of entry, providing those extra communities to have their norms heard, I think offer the best possibility for turning what Chantal Mouffe calls enemies into adversaries. Right? So think about it. Two people who are arguing in the US Supreme Court about whether abortion rights should win in a particular case or not are adversaries, and they are fighting really hard, but they're fighting within a system and within a discourse. People who are out bombing abortion clinics are not adversaries, they're enemies. People who are terrorists who are setting off suicide bombs are not engaging in the discourse, they're out being enemies. The more enemies you can turn into adversaries, the better chance you have of having a more peaceful, harmonious society, the closer you get to this ideal of the unoppressive city. So, it's an ideal. You're never going to get there. There will always be people who will be outside of the system, who will not want to engage, who will not want to play the game, and those people will get fought in wars, or they'll get put in prison, etc. This is not like a program that's going to solve all conflict in the world. But it strikes me that it could tame conflict in some circumstances, or it could tend to tame conflict by reaching both better solutions and solutions that include more points of view, more perspectives, and more communities. And if you're talking about legal systems or you're talking about legal institutions, taming conflict, at least in some circumstances, bringing more people to the table, giving more people voice so that they feel like they're part of the process, is probably the best we're going to do. And I think that at least in some circumstances, again, not in all, pluralism will help us get there. And so to that degree, I think using legal pluralism as part of the normative design of institutions and procedures is actually just as useful as the more traditional descriptive side of legal pluralism. Thank you.
Thank you very much, Professor Berman. We'll now turn to discussion questions from the audience. Michael?
Hi, Professor. Thanks for that talk. As I was reading your articles for this class and in previous classes as well, it struck me that many of the themes running through a global legal pluralism actually plays out somewhat domestically in Canada and its struggle for adoption of the multiculturalism project. So the idea that there's proponents and there are also critics saying that, well, this system doesn't work because it detracts from sovereignty. It actually on the ground plays out as increasing ghettoization or partitioning of society. And I'm wondering if in your work here or elsewhere you've kind of engaged with experiments with multiculturalism and maybe how that might feed or has fed into your work about global legal pluralism. Because a lot of mechanisms there's certain considerations that I would see playing out in both.
So partition is, to me, not a very good example of a pluralist mechanism, right? Because that's more, if you think about Iris Young's ideal of the unoppressive city, that's not the ideal of the unoppressive city, that's ghettoization. That's you go over there and we go over there and never the twain shall meet. Now, it's not to say that that's always off the table. My guess is that there are some times and in some circumstances where partition is going to be the best of a lot of bad solutions or bad options. And, sometimes, what is it? Good fences make good neighbors or something like that. And so sometimes if you've got partition, it may work. But I think in general, a pluralist approach would, instead of trying to separate, would be trying to figure out a way to include the multi-cultures within one set of processes. Now, that might mean, at least for some period of time, setting aside seats for certain groups within a legislature or within a court system or something like that. But I don't think that will lead to the same kind of ghettoization, because what that does is that puts people in a room together. And over time, I think if you put people in a room together and they're discussing things, even from wildly contradictory points of view, there will be a tendency to have a little more respect for those alternative points of view. In fact, there's been a lot of studies done about how to deal with, for instance, racism or gender discrimination in the workplace. And what has been found is that, having sessions where sensitivity trainers come and tell you how you should be better to the to the other group is not very helpful. And separating them is also not very helpful. The best way to deal with it is actually to create projects and put people from multiple backgrounds together on a project, which also can sometimes blow up, but which, at least according to the data, has a much better chance of leading to changes in attitudes over time. And so, to answer your question, I don't have specific experience with specific multicultural projects, but I would say that at least my understanding of pluralism would tend to push more in the direction of figuring out ways of having procedural mechanisms and designing institutions that would require interaction as opposed to ones that would require separation. Now, I should also say pluralism and multiculturalism, I think, are different things, because multiculturalism tends to be about specific accommodations to specific practices, and there's a bias towards the accommodation. What I'm doing with pluralism is not about the specific practices, it's about the procedures by which we would make the decisions about the specific practices. So there's a little bit different. It's a little more proceduralist.
Catherine?
Please use the microphone. Yes.
I wanted to ask whether it seems to me that your normative idea of pluralism leans a bit to some kind of formal universalism. So you have that in your paper. There are certain values that every participant in such discussions that you say will have to accept. And when you want to have a procedure for these kinds of things, everybody has to accept these procedures. And that looks as if when you go on the practical level of trying to actually find these kinds of procedures, you again try to find a set of rules that everyone can accept. You just try to make it as minimal as possible, or to make as many spaces for differences as possible. Do I understand that correctly?
I think that's probably right. So just let's make it more specific, more concrete. If you have a procedure whereby you want people from different perspectives to be sitting in a room together to make a decision about something, and one of the groups of people refuses to sit down at the table because other people there are female and not in burqas, or are African American and I don't want to talk to an African American, or whatever it might be, if you don't even believe in the ideal of having a conversation, then it's going to be very hard to turn those enemies into adversaries, right? So at some point, if you're going to have any kind of legal or quasi-legal process for deciding anything, you're going to have to get at least a minimal agreement that people are willing to talk to each other. So an example right now is in Syria. The UN's been trying now for a number of weeks just to get the warring factions in Syria into a room for like weeks. They wouldn't even sit in a room together. Well, in that situation, there's very little that pluralism, or frankly anything else, is going to do to solve that problem. The only thing that's going to solve that problem is, horrible devastation, so in one way or another. So again, this doesn't solve all the problems, and so it means that there has to be a little bit of agreement. But it doesn't have to be agreement on norms, and it doesn't even have to be agreement on a real maximal level of procedure, only the barest minimum. So yes, it's universalist in that degree, and I can't think of a way to get out of that.
Can we pass the microphone back this way?
Okay. Thank you so much for your talk. I just have a question concerning to the distinction between jurispathic and jurisgenerative. which
Yep.
is central. I don't quite understand where the distinctions lie. You say like jurispatic means like killing the multiplicity when you decide one. But this is when you decide for one option and you kill the other. But this is not quite how a legal system usually works. Anyone familiar with the doctrine of balancing or proportionality in human rights doesn't mean when you take one human right, doesn't mean you kill the other. When you take one decision, doesn't mean you kill the other option. You simply deciding because an authority pronouncement needs to be done. Or when you defer, when I tell to my younger child, do what your older boy, with my older child wants, or hear your brother or the brother, I'm not saying I don't have authority over you. So this is not, you're not killing. So, but on the other hand, when you talk about juris generative, what I could interpret is that it means three things. Is hear the other, justify what you do, and be creative in the sort of decision you are doing. And this is not so much different from the old principle of the right to audience, of due process. So when you are in a global level and you don't hear people, when you don't justify your decisions, when you don't hear other voices, you're not being jurispathic. You're simply being a bad decision maker.
Okay. Most of that I agree with. So the distinction between jurispathic and jurisgenerative is actually not my distinction. I am building on Robert Cover, who in a pretty well-known article called Nomos and Narrative talked about jurispathic judges and jurisgenerative law, although he focused more on the jurispathic, to be honest. And I think he would disagree with you. I think the way you've said it is perfectly fine, but I think what he would say is judges are people of violence in the sense that by making a decision and by choosing one legal interpretation versus another, they are in fact killing those other interpretations. Now, they're not killing it in the sense that it can't grow up somewhere else. They're not killing it for all time, but they are killing it in that moment. And so he wanted judges, and again, he was doing something a little bit different from what I'm doing anyway, but he wanted judges to be aware of their jurispathic power and not just say, oh, well, I'm just following the law. No, you're making a choice that is stamping out one thing and privileging another thing. And so he wanted people to recognize that. So that's what he meant. And then by jurisgenerative, I think for instance, he wrote a long article talking about why federalism, despite its incredible messiness, was beneficial because it allows tensions in the system to work itself out in the system. And I think he would see that as jurisgenerative. You don't have to buy those terms. Those are his terms. I'm picking up on them. But you could just call it bad judging and good judging. That'd be fine with me.
We're going to go over here. There's a bit of a queue, so you can just pass the phone through that out.
Do you have him on your queue?
I do.
Okay.
Okay, so
Yeah.
Looking at existing systems of law at the global level, so World Bank, IMF, these institutions that exist right now, if you were to look at them, there's a certain model of law, a certain system that's there already, that's been exported to the global level. So I'm wondering if your conception of pluralism goes far enough. So if you're suggesting that there should be different pluralist conceptions that are brought to the table, is that enough if the existing structure is already of a certain Western form? So to me, it kind of sounds like there's this argument for tolerance that's being made. But is that enough?
Right.
And then wouldn't dismissing it just make it that much more legitimate? Because you're saying that, well, we've listened to it, but this seems a lot better.
So first of all, I think that it's a little more than tolerance that I'm talking about, although it's not unrelated to tolerance. Some of you who were in the class read a review of my book by Dennis Patterson and Alexis Galan, in which they basically say sort of similar to the direction you're going, which is my pluralism isn't pluralist enough. It's really just liberalism in disguise. You know, it's the same kind of Western liberal ideal that will sort of bring people to the table and will allow some zones of autonomy and so forth. I think it is not the same as liberalism, and I actually wrote a response to try to explain in what ways it is similar and in what ways it is different. Just to give you an example of how I think it's different, and it actually goes a little bit to the multiculturalism question. If you have, let's say you have a community that has a vote, and they vote, and because there are more people of a particular group than of another group, everyone who gets elected to the legislature happens to be of the dominant group. In liberalism, that would be fine as long as the election were fair, and B, the dominant group doesn't take away core rights of the minority group. Okay? That would be fine. In a pluralist structure, that would not be a preferred outcome because it wouldn't allow enough dialogue. So that would be an example. So the one, you have a legislature that's fully dominated by the majority, but they are tolerant. That would be the toleration regime. Pluralism, to me, is a little bit more than that. It would say that it would actually be better to have them at the table, even if you were being tolerant, because it would be better to have them at the table. Okay, so that being said, is this not pluralist enough? Because it's still happening within a kind of framework, a sort of Habermasian kind of dialogue, and there's a sort of liberal legalism at the core of it, and maybe some would say even a kind of common law bias in the way I think about what it is that judges do and how they should act and so forth. It's possible. But I don't think that just the idea that there should be ports of entry for multiple communities and multiple voices at a table doesn't strike me as a Western imposition solely. And I think sometimes we get in trouble when we assume that all of these things are Western. You know, a lot of anthropologists for years resisted international human rights on the theory that it was sort of an imposition of Western values and so forth. And what you see in countries is people like to use those things strategically in their own ways to gain leverage in their own way, and their interpretations then feed back. And so it's not quite so simple as this is a Western thing and it's being imposed here, and these people who it's being imposed on have no agency whatsoever. And so I sort of see it as more of a fluid process. And particularly if you have a pluralist structure where more people have voice, there's more opportunity for evolution. And this gets to the jurisgenerative thing, which is if you've got more of these voices in play, it allows for more flourishing of alternative norms, alternative systems, alternative approaches to problems, et cetera. Just like in a federalist system in the United States where you've got 51 sovereignties, you've got 51 possible ways of doing an approach to regulating subject X. And that is jurisgenerative because it then leads to good ideas spreading, potentially.
Yeah, I'm also thinking. I enjoyed your presentation very much. One of my interests is game theory and its use in international law, and I was fascinated by your reference to Ludwig Wittgenstein's language games as potentially fostering intersubjectivity between the various parties. And I note that you mentioned the critical article that you had written a few years ago criticizing Goldsmith and Posner and their realist view of international relations and game theory and international relations. A lot of it has been predicated on the realist approach. Yep. I'm wondering, through your reference to Wittgenstein in your paper as part of your global pluralism analysis, whether you're supportive potentially of the use of game theory in global legal pluralism, or do you think it's something that should be relegated to the realist side of the house?
Yeah, well, so there's game theory and game theory. It's interesting. do people talk about Wittgenstein as being a game theorist? I wouldn't have thought. I mean, it's true he is talking about language games,
Yes.
and he is talking about people operating within a kind of social game structure, and they are willing to play with each other. But that strikes me as very different from at least the econometric type of game theory that people like Goldsmith and Posner are doing.
Well, that's precisely because it's different that leaves some scope for its use in the
Well, it's
context of
interesting.
your global pluralism theory.
I guess I would say that if we could come up with a game theory that is less schematic and more able to deal with the subtleties of how human beings actually interact with each other, as opposed to a sort of idealized fake version of decision making, then I would go for it. And so if we could use Wittgenstein to get to a more interesting game theory, then I'd be interested.
Yeah, I mean, he is not traditionally viewed as a game theorist, but it's a very important part of his overall.
Yeah, it's an
later
intriguing
work.
idea.
Yeah.
You know, I don't know.
We have Carolina next, and then Stephen after that.
Thank you very much for the paper and the talk. So my question
Is you mentioned in your response to Katerina that what you were looking for agreement on was agreement regarding institutional structure and the procedures we would put in place, and not agreement on norms. And I was quite interested by one of the criticisms that was raised in the paper we read for today. So this idea that could it not be the case, though, that one might suggest that the norms which underlie or which inform the creation of these procedures are themselves Western liberal ideals. And if that is, so I guess the question that follows from that I have for you is twofold. First of all, if that is the case, then might your position actually be jurispathik after all? It's just moving that jurispathik tendency one level down. So allowing for the incorporation or the acknowledgement, I guess, of different norms in this pluralist framework, but the way we go about negotiating between different norms is informed by procedures that are themselves jurispathik. And the second question I have is that if that is the case, and if that is a criticism that you'd like to address, might it be potentially addressed in the way that we could say, well, all right, we'll create sort of like a meta framework that will then outline or identify different sets of procedures, so to offer an array of procedures that is a bit more perhaps inclusive. But then I wonder, would that fall prey to the worry that it's becoming too inclusive, if that's even something that is a concern for a legal pluralist?
So, so partly my response is the same as to the gentleman on your left, that I resist a little bit the idea that certain procedures are Western versus other procedures are not Western. I think the world is much more fluid than that. But that being said, I think to some degree that's right. So I think it's very hard to get agreement about norms. I think it is a little bit less hard to get agreement about procedures, that even people who disagree vehemently about norms can often come to agreements about procedures. And that if they do come to agreement about procedures, that's better than if they're out there throwing bombs at each other. And if those procedures are viewed as coming from one tradition or another, I'm willing to allow that as a potential criticism, but say that there's really no way to have any discussion or any outcome without a little bit of jurispathik behavior, right? I mean, you can't, I said this earlier, but anytime anyone reaches a decision to go one, you turn left versus right, you're being jurispathik in a sense to the turning right. So you can't avoid it. I just want decision makers to do it more self-consciously and to do it with more intentionality and to do it more sensitively. All of that being said, having a pluralism of procedures, which was your suggested solution, I think is perfectly great. And I don't think that's too much pluralism. However, whoever is setting up an institution or setting up a procedural system or arguing for an amendment to a procedural system is going to at some point have to advocate one or a menu of those procedural systems and is going to have to select one. And at that point, you'll have the same problem. But it would be nice. I would be thrilled, for example, and now that you've mentioned it, it would be sort of a good project, is to look all around the world, both at formal legal systems and non-formal systems, and look at all the different procedural mechanisms that are used to try to bring disparate people together in a system that maybe they can agree on at least some of the time. And we might find some new ones that we don't use that often in the West, and that would be great.
It's going to take a huge team of graduate students.
Exactly, that's what I want. See, in law school, we don't have a huge team of graduate students we can send places.
Okay, next in the queue is Stephen. So just pass the mic. Thank you.
Hi, Professor Berman. I really enjoyed your two articles. The other one we read, I think they were very excellent. And my question is, how would you rank and evaluate the degree of threat to your inclusive proposal from the hegemonic regime of Anglo-American socio-legalistic values within a globalized marketplace? When you consider that, the world is sort of moving more and more towards economic integration, and that there will be certain regimes of law that will be brought to bear to back it up.
Well, let's see if I understand the question. I mean, I think that even the most hegemonic government in the world at any given moment has less power than it thinks it does. And that pluralism allows us to see that. Because one of the things that happens if we only look at formal law is that we tend to look at things like the Supreme Court said X, and we assume, therefore, X happens. But as socio-legal scholars have been telling us for decades now, if you actually look at how that legal decision then gets implemented on the ground in everyday life, you end up with a lot of people contesting, resisting, finding wiggle room, massaging that rule in ways that work on the ground or that work for particular actors on the ground or that subvert it or whatever. And so I think the same thing is true on a global level. Let's say the US, since they're always the example of the global hegemon, the US may want to do a lot of things, and they may want to ignore what other people think, and sometimes they can do it. I'm not saying power doesn't exist in the world, and power disparities make a big difference. Economic power, whether you've got military might, it's a big difference. So it's not that it has no impact, but even the United States, which seems to have a lot of power, if a group of bankers in a bar in Basel, Switzerland, figure out the rules for international trade finance, and they have, it doesn't matter whether the US likes those rules or doesn't like those rules. If it wants to do international trade finance banking, its bankers are going to have to pay attention to the rule that was developed in Basel, Switzerland. And you can see that happen many, many times in many, many different circumstances. And so I think the sort of claim to hegemony, either by those who are criticizing hegemonic power or those who think that they are exercising hegemonic power, are almost always overstated.
Thank you. That was a good answer.
I'm glad. I have one good answer.
I like the answer. I think you answered my question well.
Thank you.
In traditional legal theory circles, one of the important values that is associated with the rule of law is typically that that law makes things predictable, right? And pretty terrible things are done to people in the names of the law, right? They're thrown to jail, they're asked to cough up colossal amounts of money, and we think that, well, if that's going to be the case, at least they ought to know how to avoid this, right? The law should not ambush them. Now, tell me if I get this right. You seem to say, well, that's one important value perhaps, but a more important one is that people be able to bring to the table their conception of how things should be. Because that is going to turn enemies into adversary, is going to, as it were, pacify society, and that's more important, the kind of overall pacification, than somebody knowing in advance whether they're going to be tackled into a corner by the law, right? So so I want to know, so that's the first question.
That's part of the answer.
Okay, so that's the first part of the question. The second part is that, well, is it really the case that having the kind of plural procedure that you're proposing is going to bring this kind of taming of conflicts, right? You might have situations where traditionally people would not be able to be at the table and would be peaceful cohabitants. Now you're giving them an opportunity to talk, to be there. And so the question is, isn't the flip side of the problem here that you might turn peaceful cohabitants into adversaries and that
Right.
you don't want this? And third part of the question, if really the important value here is taming conflict, why do you want to take out the beyond the pale views? Because those seem to be those where they're going to be the most conflict and real enemies, right? So.
Okay, let's
Yeah.
see if I'll remember
Okay.
all three of them as I go. So, so your question about predictability. So I would say that's part of what you say is part of the answer, which is that, in the balance of things, predictability may be a little bit less important in my hierarchy of values than perhaps for other people. But I think there's more to it than that, which is that I don't think I don't think what I'm talking about is necessarily so unpredictable over time. And B, I'm not sure that the system we have now is so much more predictable. So, maybe this shows my bias for common law judging. But I think things that at a certain point in time feel very unpredictable, uncertain, we don't really know what the legal rules are, over time, as they get worked out in practice, start developing pathways, customs, approaches, traditions, etc., which lend a certain kind of working predictability, if not an absolute predictability. And whatever predictability so I think it is more predictable. It's not as wide open as your question implies. And the flip side is what we have now, if you're going to have a world where there are multiple jurisdictions and there are cases like Yahoo that I talked about earlier that don't fit in a box easily, then there's going to be unpredictability. And the way you solve unpredictability is you create one worldwide jurisdiction. And that would solve the unpredictability problem, but I think it would create a whole bunch of other problems. And so if you're going to have a world where there's multiple jurisdictions and multiple norm-generating communities, then you're going to have some degree of unpredictability, and that exists now. And so I'm not sure that what I'm talking about will be that much worse. And to the extent that it's a little bit worse, then you're right, my hierarchy of values would go that way. And as I predicted, I forgot the other two questions. Say them quickly.
Turning peaceful cohabitants into
Oh yes, right.
And beyond the pale.
And beyond the pale. So turning peaceful. So this is what I said. In response to the partition. Well, it wasn't really a question about partition, but I sort of talked about partition. Sometimes it may be that simply keeping people separate and peaceful is the best you can do. And that if you bring them together, you will start creating strife that didn't otherwise get created. Now, again, there's a lot of empirical data in addition to the employment one in other contexts. It's not clear that bringing people together often creates strife when it didn't exist before, but I could imagine that you might be right. And in that case, again, the values of pluralism might be overridden by other values, like the need to keep the peace or something like that. And then that's fine, right? So I'm not saying, again, emphatically, I'm not saying that these values underlying more pluralist processes always win over every other value that could possibly be there. I just think that they should be part of what is on the table when you are thinking about how you want to design a system or a set of procedures, etc. Same thing with beyond the pale. So all I'm saying about that is that there are going to be some actors or some norms that, and I'm really saying this as a descriptive matter more than as a normative matter, that some communities are going to say, look, I'm a decision maker. I cannot countenance enforcing and recognizing a Nazi judgment. I cannot do that. And I'm going to explain why I can't do that. Same thing, I can't countenance an institution that discriminates against interracial couples as being within my constitutional framework. That's beyond the pale, and I'll accept them as people within my community to some degree, but I'm not going to recognize their judgment. So I am just taking it as a given that there will be some place that people won't go, that they won't be willing to go. And all I'm asking is that that place be pushed as far to the margins as possible. And if you reach that place, you have to explain why you've reached that place and you cannot countenance it, and you put some big value on your side on the table and say, here's why I cannot recognize that judgment. And it's got to be more than just, I would have reached a different conclusion.
Three more in the queue. Stephen, could you pass that microphone along to Matt?
Thank you for the talk. I had a different question, but it's already been asked, so I'm going to try and come up with something a little bit different on the fly. And this is somewhat unfair to you because I think I'm asking you to step well beyond the purview of the paper, but...
That's okay.
Okay, good. So the question goes like this. There's a sense in which you're committed to some level of prescription, normative prescription, because you say pluralism speaks to a certain value that's important to the rest of us. If nothing else, it provides for peace, amiable discourse, etc., etc. Nothing too substantive there, right? I thought it was initially interesting that you were being questioned about the level of your pluralism, because I'm much more interested in how things go the other way, right? Taking the value of pluralism or the values associated with pluralism on their own, you can push things incredibly far. You could have a massive overhaul of the current institutions that we do. You could have, instead of any single judge deciding a case, maybe we require at the minimum a panel of judges in every case, right? You could require the development of a multitude of court systems in every system, right? Now, normally...
Could expand rules of standing. We talked about that.
Yeah, we talked about that a lot. I mean, there's the degree to which you could upend the current system and say it's simply not pluralistic enough is, I think, almost without limit. And this is where the question comes in, because you've done a really good job, I think, of highlighting, right, the importance of the values associated with plurality. What you haven't done, and I think there's no criticism here, but it's a question, is you haven't talked about what might count as acceptable limiting principles. So, for example, Francois brought up predictability. There's a limiting principle, right? Yep. Pluralism to the point of unpredictability. Another limiting principle might be, but I'm not suggesting it's appropriate, would be efficiency, right? Historically, there have been all sorts of limiting principles out there, and I can see that there might be some hesitation about trying to select within them. An example of this that's maybe somewhat surprising is you think of the Ottoman Empire. Right? Here was an empire that was very good at plurality. But
most empires were, actually.
Right, yeah. I mean, this one's in particularly famous. It had a multitude of court systems that allowed individual directorates to hold a lot of autonomy. But its limiting principles were actually religious in nature. Right? So my question for you is this: is there a sense in which, or have you begun to even think about, are there potentially appropriate versus inappropriate sorts of limiting principles on your account? This questions the kind of nature of your liberalism, because there is an association, and maybe you don't have to be any particular kind of a liberal, but it's an overreaching term. I think it's fair to say it. So are there, again, the question is just, do you have any sense of the appropriate or inappropriateness of limiting principles?
So really interesting question. So So first of all, I think you're right in your premise, which is that potentially if you accepted this idea that legal pluralism is useful for thinking about procedures and institutional structures, it could suggest that you might at least want to rethink a large number of our doctrines and our institutions and the way they're structured and the way they're set up. Now, again, I don't say that they should all be upended because the values of pluralism overtake every other possible reason why, that we do things the way we do them. But it at least would cause you to think about them. And one of the things that I'm actually working on is looking at a number of specific procedural mechanisms that you might want to at least consider if you accepted that these were useful. So, and we talked about standing, having more mixed tribunals, things like that would be obvious ones. So then the question is there any limit on what sorts of procedures you might possibly adopt? And it is true, empires were historically very good at being pluralist, in part because they had to, but one of the reasons empires lasted as long as they did, the ones that lasted a long time, it's because their control over the fuzzy hinterlands was purposely left a little flexible. If they had tried to be more hierarchical and more dominant, they would have faced much more resistance. And they were successful in part because they were pluralist, I think. And there's been some historians of pluralism who have written about that. But then are there any limits? Well, so I think there probably are limits, but I think they aren't limits that I should be setting from some Archimedean point outside of the system, right? So you're going to have a political debate about that. So let's take having 3 judges on every case rather than 1, and the 3 judges have to be from multiple communities, let's say, okay? So you're going to have a debate. You're going to have some people who say, that's great, it'll be more pluralist, more inclusive. You're going to have other people say, it's more expensive, it'll take longer, and lots of other objections. And then you're going to have a political debate about whether the values of pluralism outweigh the values of efficiency or the values of whatever. And I don't think I can be in a position where I'm going to be able to answer that question, because any answer I'll have, someone else with a different set of political commitments is going to just disagree with me, and we're going to have a debate. So that's about political commitments more than it is about pluralism. I just want to open up the space where those values are on the table to be considered as possibly important values to go along with efficiency or certainty or the rights of the defendant or the rights of the victim or all the other things we think about when we design systems. I want to be able to say, here's some other things we should think about when we design systems. And by the way, here's some things that are being used as systems. One of the advantages, I think, of my project is I'm looking at things that we're already using in the world. Things like the margin of appreciation or things like overlapping jurisdictions and federalism and so forth. And I'm providing a way of understanding why those might be useful solutions as opposed to just unfortunate compromises. But I don't think that I'm the one or that any one person should be the one who dictates a set of limiting principles. Not least because, going to the objections from that corner, it may be that other people or other communities or other people from other traditions, they may have fabulous procedures that have nothing to do with judges, let's say, that have to do with bringing together elders from the community who know all the parties to figure out a way of doing justice. And that's a much better way of solving certain situations than the one I would come up with.
Robert, next question. So we'll move back to microphone, please.
Thanks. That was your work's great, and I obviously agree with a lot of the values. In particular, trying to bring in more proceduralism, more sense of hierarchical kinds of relations that capture the reality of a bunch of different communities. But in that task, the idea that it's at the limits that where all the questions come,
Right,
because
always.
a turn to procedure in itself is a gesture to an empty kind of box without a sense of how that actually unfolds.
Yep.
And so my angle on this one, which I'd like you to speak about, because it's not so much in the paper, is the state, non-state issue. And is institutional design in your mode of a global legal pluralism institutionalized in decision-making different with respect to state, non-state relations? And here's the example. You say in your examples, you said you're using only basically public state-to-state law examples.
Yep.
And in that context, it's not that difficult to argue for greater deference, greater margin of appreciation, greater attention, because either we are speaking to ourselves, so in a federal structure, it is one tier of governance speaking to another, which may have overlapping membership. It may not be the view in the United States, but in a lot of other parts, public international law would be treated as it's another part of our governance structure, but it is we speaking.
Yep.
And so it's us in our different institutional configures relating to each other. In that context, I think it's a very sympathetic case to say, and you don't have to dig too deep into the procedural limits. But with non-state, which is your classic in the pluralism literature, this is the hard challenge. How do state authorities relate to non-state authorities? There, I guess the question would be, are there bigger qualifications? Are there tighter procedural limits? Are there, in fact, substantive limits that you would want to design in thinking about how to make this real? And so, give you one example. If we take the Lexmark, not the central bankers, but the investment bankers, setting out merchant norms, and these are presented in a concrete case within a regulatory issue in the United States, this kind of issue. How does the state respect the global pluralist values? One argument would be it should engage in every one of the techniques you've described. There should be margin of appreciation, there should be greater attention to local norms, there might be mixed participation, every single one of those could apply. But in that context, you might say, well, this may not be we speaking to we, but rather a subsection, a group that doesn't include, say, consumers or something like that. Right. And so then the role of the state authority is or it seems to be positioned differently. So I guess I just like a little bit more about the part that you didn't talk about, because you said you didn't have the evidence. I was wondering, I think you'd probably have not just different evidence would be needed, different case studies, but it seems to me that you would have very different limiting principles to make the kind of normative commitment that you're articulating here work.
It's possible. It's certainly harder. And it's harder, I think what's hardest is not so much that the non-state communities are somehow sort of crazier or likely to be more farther afield, although that might be true. I think it's not so much because of that. It's figuring out which communities are relevant if there's not sort of an obvious state nexus. So, an example would be you've got your investment banker example, and you've got Lex Mercatoria and so forth, but maybe you should include as a community, at least an epistemic community, those worried about workers' rights or the environment or some of these other things, and they're not quite as obvious a group to bring to the table or to bring into a litigation or to bring into a governmental decision-making, et cetera. Although they have NGOs as well through which maybe they can assert their norms. But it's a little bit more complicated to figure out who the group even is that you're going to talk to. That being said, I think that in your example, it is not so difficult to imagine using any or all of these procedures with regard to, let's say, merchant norms. And indeed, the US Uniform Commercial Code was created in a way just to codify merchant practice. That was part of what Llewellyn wanted to do. And so it's not even unprecedented. It's almost within America's formal law already. And so this would just be kind of making it a little bit more explicit. Another example of this would be free trade panels and adjudicatory bodies, which are controversial, I recognize, and I don't agree with every decision they make and so forth, but they are an example whereby an entity, usually a business entity, that thinks they are facing something that, let's say a state-based court decision that ran against them, thinks that that court decision violates a free trade agreement, they can go to a panel of the free trade agreement to try to get a whole different community to weigh in on this particular debate. So the question then, so I think it's not that hard to imagine the procedures still working or the institution still working. Then the question is, are there more substantive limitations that I would place? And again, I just want to push back on me placing the substantive limitations. I think what's going to happen is if a lot of, let's say, NAFTA tribunals overturn federal decisions that that we're trying to protect the environment, and the NAFTA panel comes in and says, oh, but that's hurting free trade, forget the environment, and that happens a bunch of time, you will get political backlash from those who care about the environment. And so that will be part of the pluralism, is that then local whether it's countries or constituencies within countries will then object to what the NAFTA panels are doing. If there's enough objection, my guess is that over time the NAFTA panels will start moderating what they do because they don't want to be seen as illegitimate, and you'll end up having this sort of plural interaction, in part because you've got multiple panels. You've got NAFTA panels, you've got federal courts, you've got state courts, you've got all of these different entities adjudicating what it is that commercial entities might do. And so I think I can't say that, well, at this point, this decision is a bad and illegitimate one because it's taking into account a community I don't like. I can say that as a political matter, but I don't think I can say that as a institutional design matter. So I'll draw the line one place, you'll draw the line another place, someone else will draw the line another place, and they'll fight it out, and that's the nature of politics. But I think in terms of the system and the systemic values, I think it can work even when you're talking about non-state entities. So I guess that's a partial answer, but I'm not sure if I've fully responded enough.
Just very quickly.
Yeah.
I mean, one of the an example of what I would say is the borderline between a substantive and a procedural requirement for that to work would be something like the inclusion.
The what?
The inclusiveness of the and the representation of the non-state group, right? So I think.
So who's allowed at the table?
Exactly.
Right.
And part of our core commitments in judicial process and in designing public process has been the idea that it's intended to be a reflection of the demos in the sense of the broadest set of constituencies, right? And in doing that, you frequently need to have limits in terms of, who tends to turn up, who participated in the norm setting, how well were third-party interests reflected, right? This classic oversight by public authority over civil society, right? And I guess the query is, if we kind of flip the idea of the public authority. But you would still have those things, right? You'd still have. But I think in the institutional design, it would be, where are you going to find the proxies, the equivalents to that in doing so? Don't you have to have those?
Well, but you're still going to have individual states or administrative bodies saying you haven't included enough voices, right? So you'll still have oversight of processes. You'll just have oversight of processes by both a NAFTA panel and a state panel and a federal panel and so forth. And it is true that repeat players and powerful actors will have more ability to forum shop than entities that might have less power. And that, again, power and wealth disparities are always going to exist, and I assume that anyone who has more power is going to have more ability to subvert any legal system anybody could create at any time. But I think that having those multiple voices or multiple forums do allow these multiple voices to at least have a chance to be heard, and sometimes entities that are locked out because they don't have power in one place can be heard somewhere else. And so I think, you know, if the claim is this decision-making entity did not pay enough attention to this community, then that's a claim that would be brought in some other forum that would say that was an illegitimate decision, don't recognize it, don't enforce it. Because in some sense, jurisdiction, and this actually goes to more what's in my book, not in the article. Let me back up. Quick story. When I was first writing what became this book, I was writing about internet jurisdiction. And I was writing a lot about, well, under this circumstance, a court can assert jurisdiction, and under this circumstance, a court can't assert jurisdiction. And one of my colleagues at the University of Connecticut, Carol Weisbrod, who is a committed pluralist, said, you keep talking about they can assert jurisdiction, they can't assert jurisdiction, as if you control what communities can do. Communities don't ask your permission to assert jurisdiction, they just assert the jurisdiction. And so the question is not so much, will an entity say that it's going to decide an issue? The question is, how much will other communities recognize what they did? So a lynch mob might assert jurisdiction, but nobody recognizes what a lynch mob says, or they might not, because it's beyond the pale, or because there are other procedural or normative problems. So what I think in the non-state context is that you'll have lots of communities that will be asserting things, and then the question is, can they be heard in the marketplace of recognition? Will other entities say, yes, that's actually a judgment I'll recognize? Or will it be like Garzone, where nobody recognizes his judgment formally, but it has a lot of impact informally? But we won't know unless we hear Garzone speak, or unless we hear the merchant norm happen, or the environmental norm, or whatever it is. That then allows it to be part of then the decision making that other entities will have to make. So again, I think only a partial answer, but.
Matt?
Western values thing, because
Okay.
that's when I had the idea for this.
Okay.
So I thought maybe you can answer the question whether it's not a problem that if we design procedures for a rule-guided dialogue that is with open content, these procedures might be too much influenced by Western values. Maybe you could answer something like, the fun thing about rule-guided dialogues, if they're not content restricted, is that they can be self-referential, and that they can turn into dialogues about the very rules that the dialogue is guided by,
Yep.
which means that you at least go into this whole thing with the hope that everybody who comes to the table thereby gains the power to change the rules of the dialogue and makes them less Western guided. So the picture I had in my head is if you have a debate club in high school, and the first rule is you get 5 minutes to talk, and the first person who comes up talks 5 minutes about why the rule should be that you get 10 minutes to
Right.
talk. So maybe that's a way that you could answer that.
Well, and frankly, I would argue that international human rights norms are an example of that, right? So they are norms which might have come out of one tradition, but have now been used and changed and used strategically and had more content added to them and had different content added to them, and that there's now much more of a dialogic process. But having the norms created the context for then having the changes take place. So yes, I'm happy to adopt that.
I've got a question.
Just wondering, the kind of legal pluralism that you're advocating or recommending, it seems to be quite hostile to law.
Really?
In this sense.
I thought it was turning everything into law.
I mean, I want to get your reaction to this because it seems to me that it's the opposite. So there are two
I usually get people complaining that I'm turning everything into law.
I think it's the opposite, right?
Okay.
Think about two structural features that law tends to have, and this is a bit in the same kind of flavor as Matt's question, and try and force some philosophy into the conversation. Take these two features. We expect, if people have a disagreement about what the law ought to be, suppose a community comes together. They've got different backgrounds, different beliefs, different ideas about what ought to be law. In that community, we say, well, they don't yet have law. What they're missing is law. They need a norm which tries to settle as best as possible those competing values and beliefs. And that's typically what we expect law to do. Right? In Canada, we've got all sorts of debates about whether abortion is legal or ought to be legal or not. The political controversies they endure. Right. But we've got fairly clear laws on when and under what conditions abortion is legal. So law can not solve those political disputes, but at least solve the legal disputes. So that's one structural feature I think is common to law. It tries to settle those disagreements and disputes about values. The second one is that whatever essential features law might have, people tend to agree that you've got a legal system or legal order once you've got courts that serve something of the same function, right? You've got disputes about what the law requires or doesn't require. Courts tend to try and resolve those legal disputes as well. Here's why I think your view is really hostile to those two, I think they're pretty core features of law. On the one hand is that we ought never to take settled legal norms as dispositive of disputes under law.
No, it's just settled legal norms are not dispositive of disputes under law. I'm not saying that we shouldn't or we should. I'm just saying as an empirical matter, it doesn't resolve the dispute. I don't care what a court says about abortion. It's not resolving the dispute about abortion in Canada or the U.S.
The political controversy, but the legal issue could be resolved though. Right. So if you've got multiple legal norms that are competing and conflicting, you could say one of two things in that circumstances, right? You've got legal norms that are asking of subjects and courts to do different things. So they're not just different norms; they're conflicting norms. On the one hand, you could say, well, we've just got a plurality of laws, and the courts have to navigate that plurality and try and come up with a solution of giving due consideration to those multiple perspectives. But I think equally, you could say, if all of those legal norms, those proposed legal norms that are being asserted, are getting attention or being considered, then the description shouldn't be we've got plenty of law or too much law, but we've got no law at all because we're back in that stage where the community is disputing.
Yeah, so I understand, but I think law is a process, right? Law is the process by which we try to reach provisional compromises on how we're going to get along with each other, recognizing that those provisional compromises are constantly in flux, constantly changing, constantly being challenged and subverted. And if you see that as what law is, then it seems to me what I'm trying to do is turn more and more and more and more of things that we think of as politics into law, because it will create processes for forging provisional compromises. So I guess, if you see law and the need for law as coming up with fixed rules of behavior that everyone agrees on and that are the way everyone then behaves, I think I disagree with that as a definition of law, because I don't think that's what actually happens in the world. I think law is an ongoing, iterative process that never ends, and that, you can say, well, that's political, that the legal dispute has been decided, but the political dispute hasn't. I don't see much of a difference between those two things. I think political actors are asserting norms that then get imbibed and they become the norms that get argued about in legal contexts, and vice versa, that what a court says, it gets used by political actors as leverage for their various points. But I see them as part of a ongoing iterative dialogue, I don't see one as settled and the other as in flux. So I guess whether or not I'm destabilizing law depends on what your vision of what law is and what it's doing. And maybe that's a much broader philosophical debate that I will suddenly find myself engaged in, whether I want to be or not.
What is law?
What is law, exactly? Then we're back to that. And is international law it? But you know, if it's an ongoing, iterative, structured debate, then a lot of it is law, at least in my framework.
Maybe one final question, John?
Yeah, I just want to follow up on that. One of the things that I really like, the reference to Archimedes, I really appreciated, that you're not standing outside the system, and that's the way I would frame that last thing. It's not a question of whether international law is law or not. It's more a question of, empirically, the thing that people call law, domestic law, that they think is law, it's not really what they think it is.
Right, exactly. It's, we think of domestic law as being different from international law because we think, oh, well, there's coercive force behind it and so forth. But the reality is that, what judges say is not immediately enforced unless other people decide to enforce it. Little anecdote, that's why I paused for a second. Little anecdote about that. So when I was at the Supreme Court clerking, there was a meeting of judges from Russia, from the Russian Constitutional Court and the US Supreme Court. They do that a lot. They sort of host other judges. And there was a whole day of, discussion, and law professors were there and people were giving talks about the nature of law and so forth. And it became very clear over lunch that what the people the Russian judges most wanted to talk to were the security guards at the US Supreme Court. Because from the Russian judge's point of view, the reason that the US Supreme Court had power is they had their own police force. And they wanted to know how that police force helps enforce what the Supreme Court does. Now, we know that the security guards are mostly retired police officers and they're just there to just kind of guard the building. But it was very important to the Russian judges that there was this enforcement mechanism that somehow the judges seemed to have control over. The reality is that judges in most places don't actually have control over anything. Their ability to win and have their judgments enforced depend on other people imbibing them, and in that sense it's no different from international law to domestic law. The thing that's really frustrating about the international law debate is that it purports to be an empirical debate, like we're trying to figure out whether it is law or it isn't law. But what becomes very clear is that it's actually propaganda for the position that international law shouldn't be thought of as law, masquerading as an empirical analysis of whether it is law or not. And I wish they would just come out and say, I don't think the US should be governed by any international norms for this, and this reason, rather than pretending that it's a philosophical discussion about whether it is or it isn't law.
Okay, well, please join me in thanking our professor for a really nice discussion.
Thank you all. It's a great set of conversations, so I've got a lot to think about.